defense recommended 2.5 years, 1 year to serve, balance suspended for 19 days credit, 8-year license loss. I guess it's credit to be credit for the 119 days. Guilty file on counts 2, 3, 4. Responsible file on counts 5 and 6. That's the defendant's recommendation. And Commonwealth, you're recommending 2 years in the House of Correction with a 10-year license loss, and filing counts 2, 3, 4, and responsible file on count 5, and not responsible on count 6. So we'll do that on counts 2, 3, 4. Will be on a guilty plea. I will place those on file. Count 5 will be responsible, placed on file. Count 6 not responsible. So the Commonwealth, I understand why you're looking for 2 years in the House of Corrections. It's charged OUI, initially charged OUI 5th. It was reduced, I believe, on the Commonwealth's motion to an OUI 3rd, which carries a minimum of 6 months in the House of Correction. And the Commonwealth has evidence of prior arrests or defaults in California for other OUIs, as many as 2 or possibly 3 more.
Your Honor, the Commonwealth does have in its possession a conviction from California that he actually pled guilty to it, an OUI in California, and we also have information that he is in default on 2 other OUIs.
2 other OUIs, and he has 2 OUIs here in Massachusetts, I think.
That's correct. Out of Marlborough District Court.
Out of Marlborough, one in 2000 and one in 1999.
Yes.
All right. Okay, so I understand why you're recommending the 2 years in the House of Correction. You're looking for 2.5 years, 1 year to serve, balance suspended.
First and foremost, to respond to the issue of whether or not there are out-of-state convictions. This conviction that the prosecutor is referring to is in a different name. The court records are in the name of somebody named Eduardo Torres with a different birth date than the one that's involved in this case. So there is an issue of identity on that. And as well, Your Honor, on the supposed defaults, I can't say, I think that they're in the same name, Your Honor, but they have not been adjudicated, and they should not be considered in sentencing Mr. Torres today. And as well on the issue of the conviction that should not, Your Honor, I think it is definitely an issue of identity and should not be a part of this evaluation. Your Honor, there has been a lot of discussion, and apparently there is a detainer that by the Immigration Department that he would be detained as soon as any sentence that he ultimately receives is completed. Mr. Torres has a 3rd-grade education. His family, who lives in Mexico, is very indigent. A 2-year sentence that the Commonwealth has requested would cost the taxpayers $60,000 based on an article that was published in the World Sun quoting the Sheriff's Office, Your Honor, that it costs $40,000 a year. Mr. Torres will be, as I understand it, detained after he serves a sentence. He's facing at least 15 to 21 months if he is prosecuted and convicted federally, which would only add to...
For his illegal status in the country, or is there unlawful status?
If he has an illegal status and if they decide to prosecute him, he's facing that at least a 15 to 20 month sentence based on a exchange that I had with a federal offender that I'm involved in. The facts of this case are not egregious, Your Honor. There was a .09 result on the breath test. There was no erratic operation, although Officer Wallace did have an opportunity to observe Mr. Torres driving his car, and there were no field sobriety tests that were performed because of the language barrier. I'm asking and the egregious quality of Mr. Torres' immigration status. He's got a minimal Massachusetts record. Whether he has convictions out of state or is in default out of state should not be taken into consideration as a violation of his rights to regard.
Well, the out-of-state defaults I take into consideration because I think it just shows that he's not a probation candidate, which is why I don't think probation is appropriate here. If he's in default in California and he's out here in Massachusetts, how do I know he's not going to finish his probation? I don't trust him to do what we tell him to do in terms of probation orders. So.
Yes, Your Honor, and I would expect that, based on what I've been told, that he's likely to not be able to comply with probation as he's going to be deported immediately. But if he were to return, Your Honor, he would be facing an immediate 18 months that would be suspended under the defense proposal. If he returned, he'd be in violation of probation, and he'd be put immediately back in for 18 months, so it would be an incentive for him not to return.
I think it should simply be a straight jail sentence along with a license loss. So I don't think he's eligible for a license, so it's just simply a loss of his right to operate a motor vehicle.
Yes.
As I said, the maximum he could get would be 2.5 years. There is a minimum mandatory for an OUI third, which is 6 months. As I said, I'd give him 18 months if he wants to plea out today. I don't know. I haven't heard the facts of the case. I'm not sure what would happen after trial. He could easily get 2.5, potentially followed by 10 days, followed by another 10 days. I mean, he could get some time in excess of 2.5 years if he went to trial. I don't know the facts. I've heard something about 0.09, and we all know that's over 0.08. So.
If I may, Your Honor, just in response to what counsel said about the prior conviction out of California, just to clarify on that, Your Honor, the Commonwealth does have a prior conviction out of California with the name Eduardo Torres, and yes, that's a different name than the defendant is, under while he's in court today. However, the Commonwealth would have presented evidence to you, booking photos from when this defendant was booked on his conviction for this offense, and if you look at it, it might be the same defendant that is standing here today. So,
just a photograph? Do you have any fingerprint match? That sort?
Your Honor, we do not. Well, the way that I was able to track this down actually is after this defendant was arrested, he had given them a different name. He is here under fingerprints. They discovered the other convictions out of, or arrests out of California. So that's the way that they determined that this defendant was, in fact, linked to this particular name.
Well, anyway, I'll do the 18 months if he wants to take it. Along with the license loss, which is required by statute. All right.
Credit for time served?
Credit for time served, 18 months in the house. And then he has a detainer, right? So he has an immigration detainer?
Yes.
Detainer? All right.
Your Honor, the other issue that I have is that, and I don't know if it's possible, but I've heard from others that it's possible for him perhaps to start his sentence in Georgia tomorrow or on Monday, because Mr. Torres has very limited financial resources and has a small amount of canteen money, a little radio, some shampoo, and will use that for potentially using it.
Can they make arrangements to get his personal belongings over to him? I guess they can.
His canteen money will be transferred over.
All right.
And Judge, on 6 you said not responsible?
Let's see. 6 was not responsible. Yes, thank you. Okay.
And then everything else that you said before.
Right.
8-year loss of license, do you want me to docket that?
You can docket that.
Okay.
Guilty file on 2, 3, and 4. Responsible file on 5, and 6 would be not responsible. The clerk's just going to docket this because she has to leave.
Judge, there's also a no inspection sticker, count 7.
Okay, just do not responsible.
Not responsible.
Once that's docketed, we'll call it.
I'm good, Judge.
Okay, we're all set. All right, a brief recitation of the facts.
Thank you, Your Honor. The facts in this matter that on September 24th, 2011, it was 10:44 in the morning when in the Foxborough Police Department ran a registration of a vehicle traveling down Massachusetts Avenue, Public Way, Foxborough. Police learned that the plates on the vehicle were suspended for a registry default. They stopped the vehicle, and when they stopped the vehicle, this defendant was driving. When they stopped the car, they noticed that the defendant's eyes were glassy and bloodshot. On the passenger seat, they observed a 12-pack of Modelo beer and an open 12-ounce bottle, which had a small amount of Modelo beer in it. When police asked the defendant for his name, he gave them the name Alejandro Armenta. Police later took this defendant back to the station. After they did not find any information for the name Armenta, they fingerprinted this defendant. And at that time, they learned that his name was actually Eduardo Torres. Police did issue the defendant a copy of his statutory rights and consent. He did read and understand the form. He indicated that he understood his rights, and at that time, he agreed to take a breathalyzer test, the reading of which was a .09. Your Honor, Collins also presented evidence that this defendant has a prior conviction out of the Marlborough District Court under docket 0021CR0572. The defendant pled guilty to OUI second and received 60 days in the House of Correction. Additionally, the Collins would have presented evidence that this defendant with the same name pled guilty out of the Marlborough District Court under docket 9921CR823, and he received probation with the 24D program. Those are essentially the facts of the case.
Is that what happened, sir? Mr. Torres?
Yeah.
Sir, how old are you?
36 years old.
How far have you gone to school?
4.
4? Are you under the influence of any drugs, alcohol, medication, or mental illness at this time?
No.
You are giving up your right to have a trial. You could have a trial in front of 6 jurors in district court. You could help your lawyer pick the jury. You pick them from the citizens of Middlesex County who come to court for jury duty. Jurors hear the evidence against you, and they reach a verdict of guilty or not guilty. And all the jurors have to agree on the verdict, whether it's guilty or not guilty. You could also have a trial in front of a judge alone. Whether your trial is in front of a jury or a judge, you have certain rights. You're giving up some of those rights today when you plead guilty. You're giving up your presumption of innocence. That means you're presumed to be innocent of this offense unless the prosecutor proves you guilty beyond a reasonable doubt. You're giving up your right to confront your accusers in court at the trial by having your lawyer ask some questions. And you're giving up your right against self-incrimination. That means today you're incriminating yourself. You're telling the court you committed a crime. In a trial, you would not be required to testify against yourself, call witnesses, or produce evidence unless you chose to do so. Do you understand the rights you're giving up, sir?
Yeah.
Has anyone forced you or threatened you to give up those rights and to plead guilty?
No.
Have you gone over the screen sheet with your lawyer? No.
Yes.
Was it translated for you?
Yes.
Do you understand what's on here?
Yes.
And you understand, sir, that if you're not a U.S. citizen, this could cause you to be deported from the United States. You're denied admission to the United States or denied naturalization as a citizen. Do you understand that?
Yes.
And you still wish to plead guilty?
Yes.
Are you satisfied with your lawyer's advice?
Yes.
Counsel, you satisfied, Attorney Grabark, you satisfied your client understands the elements of the offenses?
Yes.
The counts that 2, 3, and 4 will be placed on file until 4:30 this afternoon. All right. And on count 1, it's 18 months in the House of Correction. There is an 8-year license loss required by statute, a minimum 8-year license loss. So he stands committed. He's getting credit, I think, for 119 days. I believe it is. All right. He does have the ICE detainer that's going to travel with him. So, and I think he has a call from California as well, fault warrant.